Hi, this is Nona, and today, along with Jana, Kristin, and Sheila, I will be presenting our Module 6 assignment, Data, Privacy, and Security. SIPA, the Children's Internet Protection Act. What is SIPA? SIPA is a federally funded bill sponsored by Congress to provide funding to schools that have safety measures in place to block children's access to obscene or harmful content over the internet. SIPA compliance requires schools to filter their internet services and implement a formal internet safety policy. The Federal Communications Commission is in charge of overseeing and administering SIPA for E-rate purposes. It has also established broad guidelines for interpreting the filtering and policy requirements of the Act. Why was SIPA created? SIPA was created to make sure schools and libraries are filtering their internet and addressing appropriate online behavior. SIPA is enforceable due to the E-rate discounts that are accessible through compliance with the requirements of filtering and protecting students on the internet. How to become SIPA compliant? An educational entity is required to adopt and implement an internet safety policy which addresses access by minors with appropriate matter on the internet, safety and security of minors when using email, chat, or other direct communication, unauthorized access, including hacking and other unlawful activities by minors, unauthorized disclosure, use, and dissemination of personal information regarding minors, and measures restricting minors' access to materials which may be harmful to them. Let's take a look at a specific district. This district uses internet filtering technology to meet the mandates of SIPA. The goal of SIPA is to protect minors from accessing content on the internet that is pornographic, obscene, or potentially harmful. For more information, visit the Children's Internet Privacy Protection Act. How is it working out? This district has received the E-rate funding to rewire all classrooms with Wi-Fi hubs. The high school just went one-to-one with Chromebooks for all students. All high school teachers are required to teach a one-class period lesson about internet safety, and Jana attended a common sense media training through the County Office of Ed to learn how to support teachers to teach digital citizenship within their curriculum. To learn more about SIPA, go to the Federal Communications Commission page with access link here. Let's talk about FERPA, the Family Educational Rights and Privacy Act. What is this act? FERPA is a law, a federal law, protecting the privacy of student education records. It's an assurance that parents of children under the age of 18 are allowed to inspect their child's education records. And it's a right that parents have to control some of the personally identifiable information that is being held within a record and or amend a student's education record. Let's take a look at why FERPA is in place. FERPA was designed to provide students a right of privacy in regards to grades, behavior, enrollment, and other personal information. FERPA also controls how states are allowed to send testing data to the federal government. How can an education agency become compliant? Educational agencies must annually notify parents and students of their rights under FERPA, comply with FERPA's provisions regarding recording and disclosure of information, inspect and review education records within 45 days of a request, seek to amend an education record believed to be inaccurate, and finally consent to the disclosure of personally identifiable information from education records, except when specified by law. Let's take a look at how the district is compliant with FERPA. According to District Aid's lead executive director of technology and instruction, FERPA AB 1854 and now SOPIPA are driving forces behind everything we do to protect student and family data. We must ensure that all contracts that have to do with transfer and or sharing of data with third parties have an agreement in place that satisfies the provisions of each of the legislations that I have mentioned. So how is it working out? Well, this is a large reason why many times technology accelerators take some time to set up because we need to have contracts read and edited or revised by legal counsels on both sides of the fence or the contract. Also, without contracts in place that satisfy FERPA and the other acts, we do not enter into a relationship with a third party. For more information about FERPA, please see these sites. Let's talk about COPPA, the Children's Online Privacy Protection Act. What is the COPPA? Well, this Privacy Protection Act is a law that was created to protect the privacy of children, specifically under age 13. It was passed by Congress in '98 and took effect in 2000. It is managed by the Federal Trade Commission, and recent revisions as late as 2013 apply. This act specifies that sites must require parental consent for the collection or use of any personal information of a user who is under age 13. It also specifies what must be included in a privacy policy. It specifies when and how to seek verifiable consent from a parent or guardian. It also specifies what responsibilities the operator of a website legally holds with regards to children's privacy and safety online. Why is it in place? COPPA was passed to address the rapid growth of online marketing techniques in the 1990s that were targeting children. Various websites collected personal data from children without parental knowledge or consent. Research published by the Center for Media Education showed that children did not understand the potential negative outcomes of revealing personal information online. In the wake of media reports demonstrating the ease of gathering private data from children, the public pressured Congress to legislate. How can an educational agency become COPPA compliant? Well, first, all students younger than age 13 must have verifiable parental consent to provide personal information to a website, whether they are providing that information from home or from a school. However, schools must obtain parental consent for all students and then pass on that consent by proxy to a website operator. When a school grants a website permission to collect personal information, for example, by permitting students to participate in online projects or activities in which they provide personal information, it can be assumed that the school has obtained the necessary parental permission. But has it? Well, most schools' acceptable use policies require written parental consent for internet use. Under COPPA, if students are asked to provide personal information to websites, parental consent must also specifically include permission for students to provide that personal information. So, signing an internet use agreement is not enough. To comply with the letter of the law, teachers should also make sure that the sites their students visit have prominently displayed, clearly stated privacy policies that meet COPPA's requirements. Teachers should also educate their students about online safety and privacy issues. Remember, COPPA doesn't limit children's access to information, it limits website operators' ability to get information from children. This isn't always how it works out. The FTC notes that it's a jungle out there. One professor has recently claimed there is no privacy infrastructure in K-12 schools. I think our research in this class is showcasing the validity of the statement. Any company trying to do business with K-12 schools where privacy is involved is like a company trying to build a world class research facility in the middle of an untamed jungle. As we're finding out, schools and districts vary to a wide extent in the degree to which they are compliant with COPPA and the other acts we are studying. How is one particular district compliant with COPPA? Well, it's a work in progress. In District X, the director of technology was on vacation, and no one else was available to talk to me about how District X meets the COPPA requirements. However, I did access District X's iPad use agreement and District X's board policy 5028. There is no parent consent form as required by other districts for general use in grades K through 4. iPads are only provided for students in grades 5 through 8. In addition, District X has no specific information regarding which third-party vendors are privy to student data. Here are an example of 2 consent sites. In Ravenna Public Schools, the COPPA consent form includes information about various learning applications that students may be accessing in school time. And this is another district that has a one-to-one user agreement that also includes regarding the acts that we are studying, FERPA, COPPA. It also talks about Google Apps for Education, and it provides parents an opportunity to give permission for students to use these apps knowing that their data may be shared by a third party. And then there's the problem with Animal Jam. So lately in District X, students play Animal Jam at recess and lunch, and these are students from 2nd to 5th grade. This program clearly states that information is collected from children under age 13. Yet parents are not aware that their children are playing Animal Jam at recess and lunch. And I am afraid that perhaps this is not COPPA compliant, and parents should really be consenting to provide permission for students to use this program. And it's not a learning program per se, so this generates some concerns. So District X is a work in progress. To find more information about COPPA, here are several websites that one can access. All right, our final act today is SOPIPA, the Student Online Personal Information Protection Act. SOPIPA is a new law. It's been in effect since January 1st of this year, and it's very restrictive. It concerns students in California and one other state only, and it specifically targets the operators of educational websites, online services, and other mobile and online apps. So it discusses covered information, and covered information refers to any personal information which allows physical or online contact. This can include discipline records, test results, grades, special education data, and a whole host of other information. It was created to prohibit a website or online service from sharing student data with a third party for the purpose of marketing to those same students. James Steyer, CEO and founder of Common Sense Media, states, "I think this is a blunt call to industry to say that school data is for educational purposes, period." To become compliant, an operator must become familiar with SOPIPA. It must implement and maintain reasonable security procedures to protect student data from unauthorized access or disclosure. And it must delete student information if the school or district requests it. What about schools? Under SOPIPA, schools cannot use third-party vendors to manage student data, unless their contract states they will only use the data for its intended purposes, won't share data with other parties, and have and maintain security procedures. By not reading the fine print, educators can be unknowingly making student data vulnerable to a third-party vendor. So SOPIPA really focuses on schools' contracts with third-party vendors, And the COPPA focuses on parents needing to give consent for their children to access a learning app that perhaps might share or collect data from children under age 13. How is SOPIPA working out? Well, it's a little too early to know, but it is expected to be enforced under California's unfair competition law, which allows the jury attorney general to file suit for violations. Most schools are still unaware of this new law. They're unaware of how it affects educators, and they are unaware of what their responsibilities continue to be. Here are additional information sites and resources for SOPIPA. And with that, our Module 6 assignment is complete. Thank you for listening.